Hi again, everybody. Welcome back. Attorney Steve Vondran here. We're talking copyright law today. I know you guys all love that. Copyright law, federal law. Here we are in the United States District Court for the District of Arizona. Somebody asked me, what's a jury verdict form look like? What does it look like? And in these copyright cases, how do they get the damages? I know it's either they can get their actual damages. When I say they, the plaintiff. The plaintiff can seek either their actual damages, so maybe it's $1 million software license, or they can seek what's called statutory damages, which can be any amount from basically $750 up to $150,000. But how does that look when the jury's deciding? Here's a case, the ACT Group versus James Hamlin, Jody Hamlin. Now this involved, the ACT Group was a company that trained HVAC, air conditioning salesmen, and they had some sort of training system, I guess, that was really good. So, but this Mr. Hamlin was a person that worked with the ACT Group and then left and formed his own company, and not to form his own company, actually went with a different company. And they were kind of suspicious of him. And at one point they asked to see, let me see the training manuals you guys are using over there. I got a funny feeling it's similar to ours. So they get into a lawsuit. Next thing you know, the court says, yeah, that's substantially similar, the training materials, which is important for you business owners to realize. You can copyright protect your training materials. This is something maybe a lot of people don't know about. But if you have creative works of art, things that are sweat of the brow, things like that, not so much facts, but creative works of authorship, you can copyright them. And here you go. Here's one good reason why you might do it. So this guy left, and now he's using something similar. Plaintiff, the ACT Group, gets upset, files a case here in the District Court of Arizona. District Court of Arizona. This is out in lovely Phoenix, as you can see. And here was the verdict form. This is what the jury gets. They hear all the evidence. They go back and retire, as it's called. They probably wish they could retire after a couple days of evidence, but they go back and try to make a decision. Here you have it. Here was the training manual at issue. Was called No Pressure Selling, not sailing. But no pressure selling. So they wanted to say, here's a cool book. You go into somebody's house, you sell them an air conditioner. It's no pressure. This is kind of our cool little copyrighted kid here. Do you find by a preponderance of the evidence, that's the burden of proof, that there is a valid and enforceable copyright for no pressure selling registered in 1988? Well, that was probably easy because it looks like here that they went and registered it. A copyright needs to be registered nowadays in order for you to bring a lawsuit, okay? There was a Supreme Court case that came down called the Fourth Estates case. It came down and said, nah, you got to have a copyright registered if you want to get here and get through the gates, the pearly gates of federal court. So you come down here, if we can come down here, let's see, what do I got to go, next page here. Let's go next page. You come down here. So we're up here. Defendant Hamlin infringed the ACT Group's no pressure selling covered by the copyright? Yes. If you answered yes, come down here. Damages. If you answered yes to B1, do you find by a preponderance of the evidence, there it is again, that defendant Hamlin received indirect profits that are attributable to his infringement? The plaintiff can seek profits attributable to the infringement. Do you find that in the infringement of the no pressure selling? Yes, we do. Okay, let's keep going. If you answered yes to C1, please indicate the amount of indirect profits you find defendant Hamlin earned that are attributable to the infringement. Indirect profits, jury said $126,000. $126,000, that's a nice tidy sum. As to any infringements of no pressure selling registered in 1998, plaintiff may elect to receive either one, the amount of the indirect profits, okay, the plaintiff can seek that, or two, the amount of statutory damages. That's what we're talking about. This is what happens in a copyright case. Gets to the jury. You hear both the regular damages, what some people call actual damages, and then the jury fixes statutory damages, and the plaintiff gets to say, well, this one's higher than that one. Let's take this one. That was very simple. So they had the jurors here. And so we got into the statutory damages over here. If you answered yes, do you find by a preponderance of the evidence that the infringement was innocent? Now, if you can show that, it was just innocent, I didn't really know, there was maybe a page in there, I really didn't think it was going to be a good deal, a big deal. If it's innocent infringement, your damages can be substantially reduced. As you can see down here, from $200 up to $30,000 is still a lot of money, okay? And potentially attorney fees, okay? Copyright cases can have attorney fees. And they said, do you find that the infringement was willful? They said, nah, it was not innocent. This was not innocent. Was it willful? Yes, it was willful. Okay, so C6, if you answered yes to C5, then you must award statutory damages in the favor of the act group and against the defendant in an amount between $750 and $150,000. That's willful infringement can go up to as high as $150,000 per infringed title. So that's why I say sometimes we're dealing with software companies. They have maybe they're using AutoCAD on one hand, they're using Revit on another. They're both unlicensed, or they're using Vero software, very expensive software. Bingo, this can really add up, okay? Okay, so there you have it. Jurors signed it, but they also set, you can see, they didn't go all the way to 150. They set it at 126, which is in line with the actual amount of damages. So there it was. That's a day in court. Copyright infringement. That's what a verdict form looks like. That's what the jurors are going to deliberate on. And I do this for the benefit of my clients as well. Sometimes they ask me, what happens if we go to trial? This is what happens if you go to trial. This is what you're looking at, okay? So this is general information only, not legal advice. I hope you enjoyed that. If you need help with a copyright infringement claim, do a little trademark law too, let us know. Right of publicity, internet law, those kinds of things. So there it is. I hope you enjoyed. If you liked the video, go ahead, slap that thumbs up. You can give me a thumbs down too. If I really made you suffer, go ahead and hit the thumbs down. I can live with it, okay? Or leave a comment, and don't forget to subscribe. And thank you guys all for watching. I hope you're off to a great week. We got more videos coming, so we'll be talking to you all soon, okay? Have a great day. Bye now.